Hello everyone, my name is Hannah Tavik, and for my week 6 assignment, I chose to do case study number 2.24, which was Lowe versus the California League of Professional Baseball. Here are some facts of the case. To start, the plaintiff was John Lowe, a fan of the Quakes, and the defendant was the California League of Professional Baseball and the Valley Baseball Club Incorporated. So John Lowe, who was attending a Rancho Cucamonga Quakes minor league baseball game, was hit by a foul ball and seriously injured. So during the incident, what occurred was that Tremor, the Quakes mascot, was in the left field line where John had purchased his tickets and had happened to be sitting, was performing his typical game time antics, and he was entertaining the crowd when John got hit. So to give a little background on the mascot, he was a huge 6-foot tall dinosaur with a big tail, and he brought a lot of attention to himself, and he also took up a lot of space. So, without any warning or consent while he was performing his jokes and his moves, the mascot's tail happened to brush John's shoulder, causing him to take his attention away from the game. And this distraction caused John to turn his head completely around, and as he was panning back toward the game to make sure he was paying attention, a foul ball had been batted into the left field line, and he was struck directly in the face, breaking multiple facial bones. And due to this distraction, he did not have any time to protect himself, to try and deflect the ball, to try and move out of the way, or even happen to catch it before it hit him in his face. John happened to be sitting in an area of the stadium that was unprotected, so it made him very vulnerable in this situation. Some things to note in this case was that Lowe had personally witnessed at least one fan being struck by a foul ball before the time of his incident, meaning he knew the risks of being out in the open at a baseball game. The Lowe also did not request a protected seat at the stadium, even though the Epicenter did have protected seats for its fans. They actually had approximately 2,500 seats, which were protected by screens, nets, or overhead protection. So he also knew that many of the teams in the California League of Professional Baseball had mascots, and they did use them during the game, and that mascots have ultimately become an integral part of any game: baseball, basketball, football, any professional sport has a mascot these days. So the arguments on both sides of the case were that the plaintiff argued that the defendant had a duty to not increase the inherent risks at the baseball game. It's saying that they were negligent in performing their duty of this, that they did not have to bring the mascot in to the stadium in order to have the baseball game that day. And the defendant came back arguing that they did not owe any duty to the plaintiff under the doctrine of primary assumption of risk, stating that by purchasing the ticket, you are aware that you could possibly get injured at this baseball game. So the court findings stated that the original decision was granted in favor of the California League of Professional Baseball for summary judgment because they argued in the court that being out in the open, such as he was, that you assume your risk at a baseball game. Any fan of any baseball games assumes the risk of possibly getting struck by a foul ball or even a fair ball if it's a home run. So then Lowe was unhappy with this decision, so he appealed to the court that the decision be overturned, and the court did decide in a reversal in his favor. So upon the plaintiff's reversal, he explained that having a mascot is not an integral part of any baseball experience, and he also stated that there had actually been games where Tremor was not working and the baseball game was still played, and that this game did not have to be played with the antics of a mascot. They did not have to have Tremor there just to continue on with baseball game, and because of Tremor, that is what caused his serious injury, not because he wasn't paying attention, because his attention got drawn to something else. And he understood that a baseball game cannot be played without foul balls, but it could be played without Tremor. He was an unessential distraction that the California Baseball League decided upon to put him into the stands to help engage fans in the game. So the implications for the athletics/activities administrator would be that the ushers guiding the mascot should be very aware of their surroundings in order to avoid distracting fans who are at risk. The mascot should also not perform during game times where any team is hitting, so they should only perform during short timeouts, maybe during the seventh inning stretch, and before and after the game. Administrators should also warn before the game and remind during the game that those people sitting in open seats should always keep the eye on the game whenever any team is hitting. So, as the administrator, you should also assume all the risks of any game, anything that can happen, sprained ankles, hit by a pitch, food poisoning, all of that. You should assume those risks and prevent any distractions or any type of ordeal from happening as much as you can during any time of the game. Thank you for listening. That was case study 2.24. Thank you.